Right out of the gate, this judge is not here for excuses, she's here for accountability. We're diving into a case where a defendant already got a second chance after a violent robbery and still couldn't follow the rules. What happens next? A courtroom clash packed with tough love, hard truths, and zero patience for shortcuts. But here's the twist: this isn't just about one mistake. It's about a pattern the judge has clearly seen before. So the real question is, when someone keeps pushing the limits of probation, does the system keep giving chances, or does it finally draw the line? Stay locked in, because this one escalates fast.
Or I pay child support. And I always ask people when they would say, I pay child support. What, you want a cookie? That's something you're supposed to do. Like, you're not supposed to be before me on motions to revoke because you're supposed to be doing what you're supposed to be doing. What ends up happening is people are on probation. They're excited about getting probation because they thought they were going to prison. And people will stand before me and you know what they will say? I can be on probation for life. I'm pulling my life together. You can ask me to report every day. I'll do it. I already know that's not going to happen. It's sort of like when people say, I'm 1,000% sure that I'm clean. You know what that usually means? They're dirty. Anything anybody says that's beyond 100%, it's usually not true. State of Texas versus Bernardo C. Huerta. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Meredith Chacon for Mr. Huerta, Your Honor.
And are you Bernardo C. Huerta?
Yes.
Are you the same Bernardo C. Huerta who was placed on community supervision in 2022 CR 6940 for the offense of robbery on July 18, 2023 for a term of 8 years? Is that you?
Yes.
State?
Violated condition number 39 on or about the 30th day of April 2024 in Bexar County, Texas. The defendant, Bernardo C. Huerta, did then and there fail to participate in the mental health initiative evaluation in custody and comply with all rules, regulations, and instructions as directed by the court and or supervision officer in violation of condition number 39.
And just like that, the entire tone of this case shifts. By pleading true, the defendant is essentially admitting to violating the conditions of his probation. That's huge. In legal terms, this removes the burden from the state to prove the violation it's already established. Now, the only question left is punishment. And here's where things get risky. Once you admit fault in a probation violation, the judge has full discretion. That means anything from giving you another chance, all the way up to the maximum sentence in this case, 8 years in prison. So ask yourself, would you take that gamble or fight the allegation?
How do you plead to that? True or not true?
True.
All right. So if y'all want to go back and discuss things.
Okay.
All
Thank
right,
you, Judge.
thank you. You're welcome. All right, Mr. Huerta, it's the court's understanding you've had time to speak to your attorney
Yes.
in regards to your plea of true.
Yes, ma'am.
All right, do you still wish to plead true to violation of condition number 39 after speaking to counsel?
Yes, ma'am.
All right, did you understand by pleading true to violation of condition number 39, court could find it true, grant the motion, and sentence you up to 8 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 39?
Yes, ma'am.
All right, the court will find violation of condition number 39 true. Is there a proposed agreement or no?
No, there is not, Your Honor.
All right, state, what are you requesting?
We're asking that you follow probation's recommendation, Judge, which is to alter and amend conditions for DDRF and to hold the probationer, hold Mr. Huerta in custody until the Center for Healthcare Services, the Tacoma evaluation, the TCOOMMI evaluation for DDRF is completed, Your Honor.
All right, defense, what are you requesting?
Judge, my client has been in since January awaiting the DDRF, the wait.
Now, this is where the defense tries to shift the narrative, focusing on delays, long wait times, and the practical reality of sitting in jail for months just waiting for a program slot. And to be fair, that's a real issue in many systems. But here's the problem. The court isn't just looking at inconvenience, it's looking at compliance. The defendant is arguing, this takes too long. The judge is thinking, you should have done it when you had the chance. Two completely different perspectives. So what matters more here, efficiency of the system or responsibility of the individual?
Is very, very long for DDRF. There was, yes, he's pled true to not doing the eval. He did a part of an evaluation and thought he had completed the entire thing. But he would like the opportunity to do some sort of outpatient. Our understanding is the wait for DDRF is 6 or 7 months long potentially, which means he will be sitting in jail almost a year by the time that happens. And so is there anything, may I ask him if there's anything else?
Sure, but I will tell you, if you would have agreed to see them, you would have been done.
Yes,
And your 6 months would have been done.
can I, look, whenever.
All right, you want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand, state your name for the record.
Bernardo Huerta.
All right. What would you like to say?
Yes, sir, I do understand that, but it's still a 6 to 7 month wait. I have almost 2 years back time on this case already, just sitting in the jail.
Oh, do you just want to go to prison?
No, Your Honor, I don't.
All right, so here's the
But
thing.
I don't
Let's
have
stop.
to-
No, stop. Let me explain something to you for a moment. Let's go off the record for a second. I don't know why people commit offenses. You plead to the offenses that you committed. You're placed on probation. You get a motion to revoke. The reason why you have the DDRF pending is because you were here for a motion to revoke a violation of condition number 4. Guess what? If you were not placed back here for a violation for your motion to revoke, you never would have been waiting for a mental health evaluation. What ends up happening is people are on probation.
This right here is the judge pulling back the curtain on a pattern she's seen countless times. Probation sounds like freedom, but it's actually a strict contract. And what she's pointing out is brutally honest. People overpromise when they're trying to avoid prison. I'll do anything. I'll follow every rule, but when reality kicks in, those promises start to fall apart. And the judge? She's not buying it anymore. This isn't just about this defendant, it's about every case like this she's handled before. So let me ask, should courts be more forgiving when people struggle, or stricter because they've heard it all before?
Excited about getting probation because they thought they were going to prison. And people will stand before me and you know what they will say? I can be on probation for life. I'm pulling my life together. You can ask me to report every day. I'll do it. I already know that's not going to happen. It's sort of like when people say, I'm 1,000% sure that I'm clean. You know what that usually means? They're dirty. Anything anybody says that's beyond 100%, it's usually not true. So you came before me with that. You were placed on probation July. Then February 2024, you had a violation of condition number 4. And I remember you. You came before me. You were so happy to be continued and not be revoked. And now you come before me.
I haven't.
Here's the thing though.
I haven't gone out of jail.
Here's
I've been in jail
the
this
thing.
whole time.
Here's the thing. But the reason why you're in jail is because of your actions.
Yes, Your Honor, and I understand
And
that.
people will come before me, and let me just tell you what happens. Some people will come before me and they'll say, I don't belong to a gang. I don't do drugs. Or I pay child support. And I always ask people when they would say, I pay child support. What, you want a cookie? That's something you're supposed to do. Like, you're not supposed to be before me on motions to revoke because you're supposed to be doing what you're supposed to be doing. And whenever I give people conditions, or whenever probation recommends conditions for them, they want to write their own program. If you could write.
And here comes one of the most important legal principles in this entire case. You don't get to design your own probation. The court sets the conditions, not the defendant. Why? Because probation is meant to correct behavior, not accommodate preferences. The moment someone starts picking and choosing what rules to follow, the entire system breaks down. And that's exactly what the judge is calling out here. She's not just correcting him, she's reinforcing the authority of the court itself. So the real issue isn't just non-compliance, it's control. Who's actually in charge here?
Write your own program. Guess what? I wouldn't have a job. Defense attorneys wouldn't have a job. The state wouldn't have a job. It would be great. But you can't appear before the court and then decide that you're writing your own program and you deciding that you're not going to follow through and speak to the person. If you would have spoke to that person in April, your 6 months would have been done. You would have been either in DDRF or not. They would have transferred you. But you know what? You've been pushed back. You know why you've been pushed back? Because you did not want to do the other interview because you're like, I'm done. And I always tell people when you're on paper, and that's what this is a contract, you're on paper. Even if somebody tells you, we're coming here for an interview, and even if you've thought you've already done the interview, doesn't hurt you to go ahead and do the interview, then you can come to court and say, they came to me for an interview for a third time and I had already done the interview. Then we can discuss that. But when you don't follow through on what you're supposed to do, guess what ends up happening? Everything falls and you get placed at the end of the line because guess what? There's somebody there who's on probation, who had to be interviewed for mental health and DDRF. And guess what? They took your spot. That's where we are.
That's the only thing. I'm just seeing a lot of people coming back a lot of time waiting for it.
Yeah. I mean, I make rulings and there's a reason why these rulings are made. Right? And then you're also on, I believe you're on gang supervision as well.
I'm not sure.
Is he on gang supervision?
Sorry about that.
Well, were you a previous gang member?
I used to be, yes.
All right, so he was on gang supervision. So I have somebody standing before me who is on gang supervision. You know, you're given probation, the state recommended community supervision. And then you're over here pulling stuff off or trying to pull stuff off. That's why you have the DDRF.
This is the turning point. No more gray areas, no more back and forth. The judge lays out two crystal clear options: comply with the program or go to prison. That's it. No negotiations, no custom plans, no shortcuts. And this is where a lot of defendants make critical mistakes. They hesitate, they try to bargain, or they don't fully grasp the consequences. But in a courtroom, hesitation can cost you everything. The judge is essentially saying, decide your future right now. So what would you do in this moment? Take the program or risk years behind bars?
Now, if you don't want to wait for DDRF, I can revoke you. You guys can talk over what time you want, and I'll do what I will with regards to time. And guess what? You'll go to prison, you'll do your time, you'll get out. Either you're going to act right and follow the rules and conditions of society, which don't pick up any new offenses, take care of your children, stay on the straight and narrow. If you don't, you'll probably end up being a habitual, and your minimum when you come back will be probably 25, or maybe it'll be as a repeater in which case your minimum will be 15, depending on the charges. So if you want to discuss with the state and your attorney about doing your time, then you can do your time. And legally, I have to give you credit for any time that you've been in custody towards your time. So if you want to talk to your attorney about that and talk to the state about that, I'm not saying if they want to, if they agree to revocation and they want to give you a specific amount of time, I'm not saying I'm following that, but I'll consider it. All right. So if you want to talk to your attorney about that, you can. All right, defense.
Mr. Huerta, we talked over the break about whether or not you would agree to go to DDRF, and you've indicated that you do not want to do that, correct?
No, I'm trying to get an outpatient program.
Okay, and knowing that that's not an option.
Just 1 second. I'm sorry. I don't know if the court reporter heard his answer.
Can you repeat that?
I was trying to get an outpatient program. No,
Okay. That last part?
but if it's not possible.
All right, so you're trolling off. So my understanding, and correct me if I'm wrong, your answer to the defense counsel question is you're trying to get into outpatient treatment. Is that correct?
Yes, ma'am.
Oh, it's fine. He's just mumbling. And if you're not able to get into outpatient treatment, then what was the next thing you said?
I'll figure out what happens.
All right.
Mr. Huerta, I explained to you the only options in front of you are DDRF, if you agree to it, or that we have a sentencing and the judge will determine how much time you receive. Do you understand that?
Yes.
And since outpatient is not an option, would you like to avail yourself of the opportunity to do DDRF, or do you want to be sentenced today?
I guess we'll sentence.
Okay. And I advise you to go with DDRF, correct? Okay.
All right.
That's all I have to put on the record.
Thank you. All right, so he's pled true to violation of condition number 39. Is there a proposed agreement?
There's not, Your Honor. I would ask the court, I know that the defendant has stated that he would like to be sentenced. I don't think you should do that. I think you should say, hey, you're going to the inpatient. That's, I think that's a better option for him. If, I know he said he wants to be sentenced, but, and I can speak to that if the court would like to.
Sure. I mean, here's the question, Mr. Huerta. You don't get to decide whether you're in inpatient treatment or outpatient treatment. Now, they want to interview you for DDRF. Either you're going to do that or you're not going to do it. So, do you want to be interviewed for DDRF? Yes or no?
That response, I guess, might seem small, but in a courtroom, it's everything. Judges are listening for clarity, commitment, and accountability. And I guess sounds uncertain, almost indifferent. At a moment where your future is literally on the line, uncertainty can be interpreted as unwillingness. And that's dangerous. The judge even calls it out. This isn't a maybe situation. It's yes or no. This moment right here could very well be the nail in the coffin for his probation. So think about it. How much do words matter when your freedom depends on them?
Yeah, I guess.
No, it's not I guess. It's either yes or no.
Yes.
You can't write your own program. Here are your options. Your options are you can be interviewed for DDRF. And if they deem that you're acceptable to the program, that's where you're going to be. Or if you don't want to do that and you tell the court you don't want to do that, then I will revoke you. Those are your two options. Now, if the court were to revoke you, then the most I could sentence you to is 8 years. I'm sure your attorney will ask for something probably less than 8.
20 years just in deferred.
No, he's not on deferred. He's on regular.
He's going to do, oh, okay.
Yes. So, no, he's on regular. So the most I can sentence him to is 8 years. So, and he legally, I have to give you credit for any time served that you've been in custody. So those are your options. Do y'all need to discuss this again or no?
Do you want to do DDRF or do you want to be sentenced? That's not an option. The judge has told you, and I've told you, there's two options. Sentence, we don't know how much time, up to 8 years. Okay, to be.
All right, so you want to be sentenced?
Yes.
All right. You've pled true to violation of condition number 39. Court is finding violation of condition number 39 true. State, what are you asking for?
We're asking for the 8 years, Your Honor. The defendant has been to the prison in 2010 for an ag assault with a deadly weapon. I know you've seen the SIPs in this, and I know it's a robbery, Judge, but it came in as an ag robbery. This was, the defendant was stealing from an O'Reilly's. When the employee tried to stop him, he pulled a knife on the plain witness in this case, Judge. So this is an inherently scary crime, Your Honor, and so that's why we're asking for the 8 years, Your Honor.
All right, defense?
The client would ask that you give him the minimum of 2 years and credit for time served.
The court.
And just like that, the final decision comes down 8 years in prison. What started as a second chance through probation ends with the maximum sentence on the table. The judge made it clear from start to finish. Probation is a privilege, not a right. And when you fail to follow through, especially after multiple opportunities, the consequences are severe. This case is a powerful reminder that the legal system does offer chances, but it also demands accountability. So what do you think? Was this outcome justified? Or should there have been more leniency? Drop your thoughts in the comments below. And if you found this case as intense and eye-opening as we did, make sure to hit that like button, share this video, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.